Yes, Miss Kaufman, you've nearly finished this, Lewis.
Not much longer.
Good.
It's all relative.
Yeah.
Not much compared to how far we've come. So we dealt before lunch with the construction of the statute itself. I now want to turn to the international law requirements to which the appellant has had or sought to have resort for saying that the Act must be interpreted to confer a power to prosecute an incident offence. And the first case we're going to look at is the Michael Gale and Jamaica case. So this is the case whose resolution by the Inter-American Commission on Human Rights led to the introduction of the Act. And I am content to work on the assumption that the Inter-American Convention should be followed and should be, or the court should, in interpreting laws, the court should seek to give effect to a state's obligations under the Inter-American Convention. The Michael Gale case is in Core Authorities Volume 2, tab 37, and it starts at electronic bundle page 1389, and the hard copy version is 1388. Now, we've already looked at this, so I want to take us straight to the relevant obligations, international law obligations on which the Inter-American Commission drew to breathe life into Articles 8 and Article 25 of the Convention. So if your Lordships can turn to paragraph 84, it's on page 1408 or 1407, hard copy. So as we mentioned in our written case, the Inter-American Commission did not focus on the right to life. It actually focused on different provisions, but for our purposes it matters not. The obligations that they extracted plainly relate to the right to life. And at 84, we've seen this before, the Commission draws upon instruments including the UN principles on the effective prevention and investigation of extralegal, arbitrary and summary executions, as well as the model protocol for a legal investigation of extralegal, arbitrary and summary executions associated with that instrument, which have been considered by the Commission in previous decisions. And if we then look at what the relevant provisions are of those instruments, they're set out at paragraph 85, and they are paragraphs 9 and 18 of the UN principles. It's another opportunity to read those.
I think we've read this, haven't we?
And I'm very grateful. So what your Lordships will immediately see is that 9 deals with investigations, 18 deals with prosecutions, entirely distinct functions. Yes, the state has to guarantee them, but they are distinct, and there is nothing in this instrument that compels the same authority, the same independent authority, to do both. And then paragraph 86, the Minnesota Protocol, again, focuses on investigations and says nothing there about prosecution, certainly far less that the prosecutorial function has to be discharged by the same body. So we then turn to the facts of the Michael Gale case itself and see what was the subject of complaint, or the object of complaint. And this is at 92 to 94 of the judgment. That's page 1412, hard copy 1411. Petitioners have also challenged the propriety of the investigation in Mr. Gale's case on the basis that the same police force implicated in his death was also responsible for investigating the circumstances of his death and therefore was not independent. And at 93, if your Lordships read that paragraph.
Yes.
bottom of 93, the next subparagraph, in cases in which the established investigative procedures are inadequate because of lack of expertise or impartiality or because of the apparent existence of pattern of abuse, government shall pursue investigations through an independent commission of inquiry or similar procedure. At 94, accordingly, the Commission considers that in the present case, the investigation into Mr. Gale's death should have been conducted from the outset by a body independent from both the Jamaica Constabulary Force and the Jamaican Defence Force, with the authority to fully and effectively investigate both of these bodies and their respective roles in Mr. Gale's wrongful punishment in a manner that would result in the criminal prosecution and punishment of those responsible. And then at 96, there is an analysis of the powers of the PPCA and, in fact, its role in this particular case. And it's from this analysis of the Commission that its powers are inadequate that we then see the Act being introduced. We can see that at paragraph 97.
Yes.
And we can also see...
You say what is said in 96 is wrong, did you say? I misheard you, sorry.
No. It's because of the observations about the limited nature of the PPCA's powers that the Act was introduced.
Yes.
In other words, yes, it was an investigative body and it was independent, but it didn't actually have sufficient powers to meet the
But it's all driven towards investigation.
It's all driven towards investigation. And then they do come on to prosecution, but we have to see what they say about prosecution.
Yes, before we get there, if I should just mention that in tab 14 in the volume 1 of the authorities, we are meant to have the PPCA, certain sections of the PPCA. I don't know about my colleagues, but my copy has a duplicate of tab 15, the police service regulations. And I'd certainly be anxious to see the relevant provisions of the PPCA at some stage. I don't know if my colleagues are in the same boat.
I have a PPCA.
Yes, something seems to have...
Something may have gone wrong with my copy, but could I ask someone to produce a copy for me?
It's certainly here on the electronic form. Obviously, discrimination against Lord Hodge.
Yes, it's all right.
Unaccountably.
It's all right. I can see it electronically then. Yeah.
So, turning, I'm sorry, I'm just going to turn back to this judgment then. So, at 97, we can see that they look into, there was an inquest that was conducted, and that inquest found that Mr. Gale had been unlawfully killed, and there was a recommendation that the officers should be charged with manslaughter. And so the court there considers whether or not the independent investigative function performed by the coronial process was sufficient to meet the duty to investigate effectively and prosecute effectively. And you'll see at the bottom of that paragraph, the answer is no, because they don't have the power or an inquest does not involve a prosecution. And so they went on to look at 98 onwards at the effectiveness of the prosecution in this case. And can I ask your lordships to read 98 to 102? It's not actually as long as it looks, because quite a lot of it is footnoted, just to see what it is that the complaint was about there.
This is really taken up with the analysis of the evidence available, and the failure of the DPP to act upon it.
Yes. So it's not a systemic complaint that the DPP is an improper authority to discharge the state's obligation because there is a need for the same body to do both investigating and prosecuting. This was an operational failing in that the DPP was hampered because of the inadequate investigation in discharging her prosecutorial function. And so the prosecution was ineffective because the investigation was ineffective. And your lordships will note that they make the same point as is made in Strasbourg jurisprudence, that these obligations are obligations of means, not ends. So you don't have to prosecute successfully in every case. That may be wholly inappropriate. But you have to effectively gather the evidence that will enable you to make a decision about whether or not you should prosecute. And that was impossible in this case because of the failings in the investigation. So there is nothing in this case that supports the appellant's contention that in order to meet its international law duties, the state must establish machinery for the investigation and prosecution of offences arising from the unlawful use of force by state agents.
Parallel machinery, in fact.
There's nothing here that says it cannot establish parallel machinery. And that's unsurprising. I mean, that's what many, many states do, and that's exactly what we do. And the good reason for doing so is that you have a body that is expert in prosecution and you have a body that is expert in investigations, much as we have with our police here and with our CPS. And there is nothing absurd, to meet the absurdity argument, in setting up a system that operates in that way. Ramsahai is a case from Strasbourg that's also relied upon by the appellants, and it's to precisely the same effect. It looks at the jurisprudence on the right to life, and under Strasbourg jurisprudence, the court has implied into the right to life an obligation on the state to conduct an effective investigation into the use of unlawful force by state agents, and similarly, no obligation to create a single mechanism for investigation and prosecution. That is at Core Volume 3, tab 47. So this was a shooting by a police officer, and for the first 15 hours, the investigation was conducted by the local police force before the independent investigator came on the scene, and that formed the basis of the complaints, amongst a number of complaints brought on behalf of the victim who died. If one turns to 321 to 325, the principles are set out. That is 321 to 325, and that's on page 1819 in the hard copy and 1820 in the electronic copy. And the principles as to what is required by way of the obligation to conduct an effective investigation are set out. And if your lordships will read those.
Your essential point is that these international obligations speak to the need to have machinery in place to conduct proper investigations and to carry out prosecutions. They don't, well, except in the UN case, but they don't address the question whether there should be two different systems of prosecuting. There may be a case where an examination of the actual deficiencies in prosecution, but nothing in them suggests that by reason of the deficiencies in the prosecution that there ought to be a separate body
Yes.
conducting prosecutions
So-
as well.
Exactly. So they require that the investigative function and the prosecutorial function are conducted independently of the police,
Yeah.
but they do not require that those two functions are carried out by the same body.
Right.
It's as simple as that. There is absolutely no jurisprudence that sets out that requirement. And if your lordships, having read that, those passages which set out the key principles of what is required in order to meet the duty to conduct effective investigations, if one goes right back to the holdings, just for ease of reference, H12 through to 15, this is on page 1769 of the hard copy, 1770 of the electronic bundle, and you'll see that there is no complaint whatsoever that the investigator and prosecutor have to be the same body, no requirements spelled out.
Yeah. In other words, these were deficiencies in the actual investigation and prosecution.
Yes.
They weren't addressing the question whether institutionally there requires to be a coincidence between investigating body and prosecuting
Exactly
authority.
that, and more than that, there is no authority that says that is what is required.
Yeah.
And if one steps back a moment and thinks about it from a position of principle, there is no reason why the two should be conducted by the same body.
Mm.
So,
Yes, in fact, in 345, summarised in H15, the court seems to be accepting that if there is an independent public prosecution service, that is sufficient.
yes. I mean, in this instance, the public prosecutor actually also performed an investigative function. So
Yes.
they did a bit of both, but it was in no sense that was required.
No.
Well, there are lots
And-
of jurisdictions where the investigation and the prosecution authority, most notably perhaps in France,
Yes.
they are undertaken by the same agency. But it seems to me your essential point is, where you've got a DPP and you've got an INDICOM, it doesn't mean that because you're the investigating body that you should also be invested with the power to prosecute.
That's exactly the point.
Yeah.
And if one looks at the terms of Section 94 of the Constitution, which it's worth turning up, it gives to the DPP, one, it confers constitutionally the independent status of that body. So you couldn't have a more independent body than one that is whose independence is guaranteed under the Constitution. And two, it gives her plenary powers to institute a prosecution.
Of course, it would be a matter for grave concern if the investigation conducted by INDICOM didn't result in a proper prosecution, but you say that's beside the point so far as the present case is concerned, because you can't reason back by reference to any avowed deficiencies in the prosecution to enlarge the powers of INDICOM.
Exactly, exactly. You have to appeal to a legal obligation that they be separate, as opposed to a failure in the operation of the DPP's office.
Right. Right, where are we now then?
So, finally, before we turn on towards Mr. Diah's appeal, one other matter that the appellants have relied upon is the existence in other statutes of express provisions excluding the power of the relevant statutory authority to prosecute for offences. And that takes, again, the appellant nowhere, because insofar as applying the principle of implication, these bodies would ordinarily enjoy the power to prosecute because it's in support of or ancillary to their statutory function, Parliament may consider, well, actually, it's not appropriate for them to do so in this particular case. They're not particularly well equipped to do so. And in those circumstances, it would have to make express provision to prevent them from prosecuting in order for the implication not to take effect. So it takes them nowhere, the fact that Parliament has not made express provision to prevent prosecutions for incident offences, because the appellant still has to establish that right exists in the first place.
So you say it'd be akin to Section 33, if in the other statutes there was a Section 33 offence, then all that's happening is that the right of that body to prosecute for that offence has been excluded.
Exactly. Exactly. It simply doesn't take them anywhere. So can I then turn to the Diah conviction appeal? As your lordships will have seen from our case, we submit that the Court of Appeal reached the right conclusions on two alternative bases. Either the Court of Appeal was right to conclude that there was lawful excuse or justification on the part of Mr. Diah to take the course that he did, or, albeit the Court of Appeal addressed this on the basis of lawful justification, the matters that they relied upon to give lawful justification actually demonstrated that Mr. Diah did not have the necessary mens rea because he was operating on the basis of a mistake of fact. So can I deal with lawful justification? It's important that we start by looking at what it was that Mr. Diah was actually charged with. And you'll find that in pages 8 to 10 of the electronic bundle in core volume 1 of the record. So, page 8, first charge, without lawful justification or excuse, obstructed the Commission in the exercise of its functions, in that it terminated the Commission's access to weapons relevant to the Commission's investigation of an incident. So it terminated the Commission's access to a weapon. And then at 10, without lawful justification or excuse, failed to comply with a lawful requirement of the Commission in that he disobeyed a requirement to produce weapons relevant to the Commission's investigations that were in his possession or control. So the complaint all relates to, and the charge is, Mr. Diah's refusal to hand over the weapons. And if we then turn to the evidence that was considered or was before the magistrate in relation to that issue, if we can start at page 30 of the same record, paragraph 76 to 81. This is in the evidence of Philip Anderson. We can see at the top of the page, my name is Philip Charles Anderson. I work for
sorry, we're going to...
I'm so sorry, page 30.
Electronic page 30.
All pages 30, yes. Yes, electronic page 30.
Yes, thank you.
So it's Philip Charles Anderson. I work for the Independent Commission of Investigations as a forensic examiner. If you then go down to paragraph 76 and read down to 82. And then,
Yes?
if you can turn on to page 34, at the very bottom of that page, you can see that Lauren Campbell was sworn. And Lauren Campbell, also, paragraph 105, I work at the Independent Commission of Investigations. And he then explains that he was in the Jamaica Constabulary's force as well before he retired. So if your Lordships now read 110 down to 114. And then
Yes?
he was also asked about the applicable directions that were in force at the time and the procedure, and that starts at 126, paragraph 126 on page 38, electronic bundle page 38. Procedure was not a new procedure, it was added to our list of things that we do in 2013. If you read to 128,
Yes?
and then 132, all the way through page 39, 40, to page 41, where the answer is, yes, ma'am, I agree with that.
Yes?
So what we have is a new procedure being introduced in February 2013, and here the officer accepting, the Indicom officer accepting that this had not been put into any force order until February of 2013, and this incident happened in August of 2013. If we look at the applicable...
Not put in a force order until...
February 2014.
Yes, sorry, did I not say...
That's the top of page 41.
I'm so sorry, I meant 2014, yes. So it didn't find its way into a force order until 2014, February. So I want to take us back now to the directions, not the force order, but the directions that were in force at the time on the part of Indicom, and then we'll look at the power pursuant to which those directions were made.
Could I just ask, what's the purpose of examining this evidence?
The purpose of examining this is to show that Mr. Diah had lawful justification for refusing to hand over the weapons. So we need to see what it was that was the concern.
Well, can you summarise for us what is the lawful justification? At the moment, I don't see it.
So the lawful justification lies in directions issued by Indicom in February of 2013, January of 2013, February of 2013, which permit Mr. Diah himself to package up the weapons and deal with the weapons, and those directions themselves are made pursuant to section 22, and under section 22.3, Mr. Diah is obliged to comply with the directions. So that's where we're going, but I need to take you there.
It's not so much a question of him being required to comply with the directions, but he was permitted under the directions to do what he did. That's what you're saying.
Well, under section 22.3, he is
Failed
required
to
to
do what he
comply, and those directions gave him permission to do what he did. So he's complying with those by doing what he did. That's the point. So we do need to look, we need to understand what it is he failed to do and what he was obliged to do under the relevant law. So, if we can look at the relevant directions applicable at that point in time, they are on page 102 of the core Volume 1. If you look at 104, we have the preamble. You looked at that yesterday. Worth skimming over again. And then we have a specific direction or a specific paragraph that deals with confiscation, labelling and storing of weapons of offence. And we looked at some of this yesterday. We didn't look at all of it. And if we turn to page 120 and look at 13.2b, where a weapon of offence is confiscated by a senior or responding officer, and you'll remember that Indicom accepted that Mr. Diah was a senior responding officer, and we know that he was in possession of the weapons. Said senior responding officer shall cause it to be sealed in the presence of the Indicom investigator or forensic examiner. Now, he didn't object to doing that at all. He objected to handing it over. C, the said senior responding officer or investigator shall, upon seizure of the weapons, issue a receipt to the officer. And then E, the said senior responding officer or investigator shall exercise all due care and skill in handling and storing the weapon seized, and then shall ensure that the weapon is individually tagged, sealed and packaged in the manner prescribed by Indicom. So he can do it himself.
But did he? I thought he put them in the boot of his car.
Well, he objected to handing them over, and he was charged with failing to hand them over. That's what he was prosecuted for, and that's what he objected to doing, and that's what they...
Not failing to seal them up.
No, that wasn't the complaint. The complaint was that he didn't hand them over when he was ordered to do so. And it's important that one sees precisely what the terms of the charges were.
In measuring, you're coming on shortly to mens rea, but in measuring what he did he cause them to be sealed up in the presence of the Indicom investigator? No.
But that was not the basis upon which he was charged. He
No,
was
but
charged.
we're trying to judge. I mean, you're coming on to mens rea shortly, but the fact is he didn't carry out the directions of this protocol either, did he?
But he wasn't charged with failing to carry out the directions of this protocol.
No,
He was
but
charged.
my Lord is asking the question, did he fail to carry out the directions of the protocol? And I think the answer to that must be yes.
Well, I think there's no evidence as to whether he sealed it himself. He took it to his car. I'm not sure what the evidence is about what he did before he took it to the car.
I thought they weren't sealed at all. That was the impression.
I thought they were placed in the back of the car unsealed. That may be wrong.
Back of the car unsealed or
Unsealed.
not?
Unsealed.
Unsealed. Yes, I think he just put it back in the back of his car because he was asked to hand them over and he wasn't prepared to hand them over, and therefore he sought advice, tried to find out what it is he was supposed to do, because his understanding was that he was entitled to keep the weapons
He
himself.
certainly wasn't entitled to keep them if he was instructed to seal them and didn't seal them.
He wasn't instructed to seal them, he was instructed to hand them over.
Well,
And that's what
let's look at the provision.
Yes, if you look at what he was asked to do, he was asked to hand them over because there was a...
But he had a personal responsibility anyway, didn't he? He never mind what he was asked to do. He should have sealed it, shouldn't he?
Yes, he had that responsibility, but what he was being told to do was to hand it over so that it could be sealed by the Indicom officials. And his issue was with handing it over for the purpose, or to the Indicom officials at all, for the various reasons that he gave.
Well, there were two legitimate options open to him. One, he could hand it over, or two, he could seal it. He didn't do either.
Yes, but what he was actually charged with, the offence upon which he faced a criminal sanction and prosecution, was for failing to hand it over to them. Mm-hmm. And for that offence, he was complying with the directions in that it entitled him to hang on to the weapons himself and deliver them to the forensic lab, which is what he did.
The paragraph I've got in mind, I think, is 114 on page 36, the electronic bundle.
Is there an electronic number for that?
Yes, 36. I'm not giving these weapons to put in any box. I'm taking them to the lab right now.
Mm-hmm. Yes.
So that's not what he was charged with.
Yeah, he was charged with refusing to hand over those weapons, and that's what he refused to do.
But he doesn't.
I'm not giving these weapons to put in any box. It's a fairly slender defence, if I may say so.
I'm investigating a crime and you're investigating an incident. He was asserting his primacy over the Indicom's inquiry.
Well, he was also questioning...
See, there's no question of him seeking to comply with paragraph 13, is there?
But he was fundamentally concerned about whether or not he was entitled to hand the weapons over because of the firearms legislation. So his concern lay with handing over the weapons, and what he was being asked to do was to hand over the weapons in order that Indicom could carry out the exercise of sealing and boxing up the weapons. And his refusal was directed towards the handing over of the weapons for that purpose to Indicom. And so if one looks at section 22, so that's volume 1 core volume, tab 8, section 22, which is at
30.
yes, at 930 on both. We see, first of all, that the Commission in subsection 1 shall have primary responsibility for the preservation of the scene and may issue directions to the Commissioner. So they've issued those directions. Those are the directions that we've just looked at. And then at subsection 3, it shall be the duty of any member of the security forces who is at the scene of an incident, or in any case where there is more than one such member, the member senior in rank and command, to take such steps in accordance with directions issued under subsection 1 as are lawful and necessary for the purposes of obtaining, preserving the evidence. And that is what he did. He held on to the weapons in accordance with the directions as he was entitled to do, and that being the basis of the charge against him.
Just a moment. Section 22, subsection 1. The Commission shall have primary responsibility for the preservation of the scene and may issue directions to the Commissioner or any other authority for the purpose of this section. Directions were issued to Mr. Diah, weren't they?
So the directions are the ones we've just looked at.
Yes, I know.
So those directions, so it's issuing directions is formal directions, not a command on the ground. It's a formal issuing of directions, because we could see that from the next subsection, 22.
It's not issuing them to Mr. Diah, it's issuing them to the Commissioner.
Yes, exactly.
Very fine.
But he then, under subsection 3, is obliged to comply with those directions.
But in turn, the Commissioner implements those measures by an order.
Yes.
And your point, as I understand it, is that neither in the directions issued to the Commissioner nor in the order issued by the Commissioner was there any requirement to hand over the
That's a separate point as well. So there are two routes here. One is subsection 22.1 plus subsection 22.3, which relates the directions directly to Mr. Diah. He is under an obligation under 22.3 to comply with those directions. But there is also the further vehicle by which those directions are given effect, which is contained in section 22.2, and that is through the Commissioner of Police implementing measures to give effect to those directions. And that's the force orders point. So the way in which, as was accepted in the evidence we looked at, the way in which the Commissioner of Police communicates orders to officers is through force orders. And there's no issue about this. The relevant force orders at the time said absolutely nothing about handing over weapons. So one of the major problems here that this case demonstrates is a failure between what it is that Indicom is requiring and what is communicated to officers on the ground. And they simply don't know what the processes and procedures are. They don't know what their obligations are under the law in terms of obeying orders issued by Indicom, because they haven't been told by the Commissioner of Police what the impact of the act is. And so we have, and this is what the court was talking about in terms of inconsistencies and incompatibilities, you have a protocol, you have a set of directions which themselves are inconsistent with the orders that are given on the day, on the ground. You have a force order, which officers look to see what it is they're obliged to do, which is inconsistent with the orders given on the ground on the day and inconsistent with the directions issued by Indicom, which under subsection 3 an officer on the ground is required to adhere to. So you have a whole set of confusion here, and
It's a pretty sorry state of affairs, isn't it, in North Scotland?
it is a pretty sorry state of affairs. It is, and that's why this case is important, because it obviously, it will, one hopes, identify the nature of the powers, the hierarchy of the powers, and in that respect, the relevant authorities can follow up by making sure that everybody understands exactly how this piece of legislation operates and what the duties and obligations of police officers are in respect of directions given by Indicom. But as things stood on the ground on that day, there was a force order in place that said nothing whatsoever and put him under no obligation. There was a direction issued by Indicom that he had to comply with under subsection 3, which allowed him to keep hold of the weapons. He himself sought to clarify what it is he was supposed to do from those in command of him, and in the end, in our submission, acted with lawful justification in refusing to hand over the weapons, because that's what was permitted under the direction, the February 2013 protocol issued by Indicom itself.
So you say that his retention of them was not unlawful?
So his retention was not unlawful, yes. It was consistent with the directions. Now, in the alternative, if that is not sufficient to give lawful justification, I can deal with this.
Just before you move, is there nothing in the February 2013 direction which enables an Indicom official to, as it were, override the standard procedure set out in the direction in the light of the situation prevailing on the ground at the time?
Well, in my submission, no. This is, as it were, the lex specialis. This is what is dealing specifically with the handling of weapons, paragraph
I understand that, but it's still setting out standard procedures.
Yes.
I'd just be slightly bemused if they were so rigid that they couldn't be moulded to suit the exigencies of a situation on the ground by the investigating officer in charge of the investigation on the ground.
In my submission, that is not the way in which these directions work. These directions provided a very clear code as to how weapons, which may have been involved in an incident, were to be handled, and that was the basis upon which Mr. Diah acted and operated. So,
If he was operating on the basis that the investigator couldn't have a hand in handling or storing the weapon, then how is that consistent with 13.2e? The said senior responding officer or investigator shall exercise all due skill and care in handling and storing the weapon seized. I mean, there's no prohibition here on the investigator having access to the weapon.
he is entitled to keep hold of the weapon.
What?
He is entitled. So that direction, paragraph 13, subparagraph 2e, confers two mechanisms, two means by which the weapons are going to be handled, secured, and so forth. One is the investigator, the other is through the senior officer, the responsible.
I thought one of his points was civilians weren't allowed to have weapons.
Yes, he was extremely concerned about that.
These directions don't suggest that's the case, do they?
They don't. He was wrong about that, but that was his concern. He was wrong. So one has to... So firstly, there's what's in his mind. Secondly, there is what is the lawful justification that's afforded him. The lawful justification comes from the terms of the directions, and those directions permitted him to keep the weapons himself.
Could you just help me with this? We were taken to page 114, electronic bundle, page 114, paragraph 8(2). Senior responding officer should surrender to the investigator any physical evidence, including any weapon of offence.
Yes. And my submission on that is that that is the general provision, and then the manner in which that is going to be dealt with is provided for in paragraph 13. So that is the, as it were, the lex specialis. So where one's talking about surrendering, you surrender in the mode identified in paragraph 13.
By not surrendering at all.
Well, you surrender in that you provide Indicom with everything it needs in order to have that weapon forensically tested and assessed. But it is clearly contemplated that that can be done through the most senior officer responsible. And again, I come back
Well,
to...
it seems a remarkable situation that he can comply with 8.2, which enjoins him to surrender to the investigator any physical evidence collected at the incident scene by refusing to give the weapon to the investigator.
Well,
That just seems completely bizarre.
if and insofar as surrender is understood to mean physically surrender. Well, I come back to the point that we
Well,
were...
what other connotation do you place on it?
Well, can I bring it back to the point we were discussing earlier,
Yes,
which is that
certainly.
mechanism of investigation. So Indicom can act on its own, but it often doesn't act on its own. It acts with the assistance of the police. And so there is nothing inconsistent with the concept of surrender in it being a police officer, and what has been identified in the direction is the most senior police officer responsible, taking charge of the mechanism by which that instrument is surrendered. So it isn't so extraordinary that the senior officer should be assisting Indicom in securing the process of the surrender of that weapon.
But he does so under the direction, management or supervision of the investigator. And in this case, the direction, management and supervision by the investigator involved a request to hand over the weapon.
Yes.
So if you read 8.2 along with 13, where is the justification for what he did?
Well, you have my submissions. 8.2 has to be read together with 13 because 13 makes special and specific provision for the handling of the weapon. And that's...
I beg your pardon. Page 110, in answer to my Lord Briggs's question, does paragraph 4.3 help that an investigator at the incident scene may issue instructions to any officer attending the scene?
Yes.
So is that the override, or is that an override of the kind subject to my Lord's question?
Well, my submission on that is that it is again subject to what is there provided in paragraph 13.
I see. Yeah.
So where the direction itself makes provision and covers the area, then any direction has to be consistent with that.
I mean, one way of reading paragraph 13 might be where it says the senior responding officer or the investigator is that if the investigator is not there, then it must be done by the senior responding officer. But if they're both there, then you look elsewhere in the rules to see who takes over and takes primacy in relation to it.
I think it contemplates the intercom officer being present at the time. I think on reading of 13.
Well, 13.2b probably does.
Yes, 13.2b
In the sense you
definitely
probably
does.
have to wait until the investigator or the forensic examiner is there if you're the senior responding officer before you seal it.
Yeah.
But not 13.1
But
or
the critical one,
13.2a.
13.2e does, because 13.2e involves sealing again. So it does appear that the investigator would be present. So those are our submissions on lawful justification, and if
Could I just ask the provision in section 22 appears to contemplate two stages. You get a direction from the Commission to the Commissioner of Police, and then you get an order from the Commissioner of Police to his troops.
Under
Now,
two.
Under two. Now, are these other provisions in 8.2 and 4.3 reflected in the orders given to the standing order to the constabulary? Are these other provisions in 4.3 and 8.2 of the Intercom direction reflected in the orders which are given to officers by the Commissioner of Police?
Can I come back to you on
Yes,
that,
please.
my lord?
I'd be
Because
grateful for
I
your
really
assistance.
can't give you the clear answer because I haven't, at the moment, seen every single protocol that there has been.
The other, just for completeness, I think the other part that we were taken to, paragraph 4, 6, Roman 6 and Roman 7, on page 111. But I think your answer to that would be the same.
Yeah, so if you look at who it's addressed to, the senior responding officer, 6, referred to in subsections 4A and B, shall take such steps as are necessary to ensure the fulfilment of these directions and shall confiscate and label the firearms and ammunition of all members of the JCF, that's 7, provide further support to the investigation of the incident pursuant to the request made by Intercom, and that is again, further provision is made in relation to that in paragraph 13 with respect to how the weapons are handled. So yes, it would be the same. So the alternative argument is that all the matters, and I won't take your lordships to them, but for your lordships' pen, we deal with this in our case, but the matters set out by Justice of Appeal Phillips at 97 to 99, Electronic Bundle 362, and her conclusion at 100, that the level of uncertainty, that all the factors being identified created, and the fact that Mr. Diah followed the instructions of Superintendent Pinnock gave rise to lawful justification and excuse, in our submission would and are properly to be characterised as matters that gave rise to a mistake of fact on the part of Mr. Diah, such that he didn't have the necessary mens rea to commit the offence. And I add into that the additional findings of Justice of Appeal Frank Williams at page 420 of the Electronic Bundle, paragraph 234. And we cite the authority of Gladstone Williams in our case, which is at Electronic Bundle 1555, volume 2, tab 39. And for those reasons, we submit that the Court of Appeal was correct in concluding that the conviction should be quashed and cannot stand. If your lordships are of the view that that decision should be reversed, then as we've indicated, we would ask that this matter be remitted to the Court of Appeal to consider the sentence on the basis that the Court of Appeal didn't actually properly consider the sentence. The only judge who did do so was Justice of Appeal Brooks, who, having dissented in relation to the majority, necessarily needed to go on to consider sentence. But if we look at the judgment of Justice of Appeal Phillips at paragraph 101, and that's the Electronic Bundle at page 364, she makes it quite clear that this is not an issue that she has given proper consideration to. Page 364, 101, For my own part, I wish to state that the sentences given to Mr Diah do not appear to be manifestly excessive. However, given my own view as to the disposition of this appeal, I find it unnecessary to comment any further on this in respect of this ground. And Justice of Appeal Frank Williams made no observations whatsoever on the sentence, and in those circumstances, in my submission, it's impossible to say that this matter has been considered already by the Court of Appeal. In my submission, there's no good reason for this court, this board, to take anything other than the ordinary course and remit the matter back to the Court of Appeal. There is a great deal in our submission that can be said by way of mitigation. The summary of what the magistrate took into account is at electronic bundle, page 721, in the Statement of Facts and Issues, paragraphs 6.1 and 6.2. So that's page 721, paragraph 6.1 and 6.2.
Could you give me the reference to that again? I'm so sorry.
6.1 and 6.2 on page 721. So this is the Statement of Facts and Issues.
Thank you.
And possibly the first sentence of 6.3.
Yeah. Sorry, I'm so sorry. I'm trying to get my...
Yes.
It's just prior history of cooperation
Usually
with...
cooperated.
Oh, he usually cooperated, yes. So thank you, thank you. Yes, so those are the factors that we're taking into account, but there are many more that in my submission it's appropriate to consider. So we have to remember that when this happened, this was in 2013, the Act was very, very new, and we've seen from the nature of the directions and the mismatch between the directions and the orders that were then being given, the forced directions which were in place at the time, that it was a recipe for confusion, and people on the ground, officers on the ground, didn't understand. And Mr Diah clearly was seeking to ascertain what it is that he should have done. And in my submission, it is right that a court should have a proper opportunity to consider that factor, coupled with what the possible implications might be for Mr Diah. So Mr Diah is a senior officer who, unlike other junior officers who have been found to have committed Section 33 offences and who would fall to be dealt with by the Commissioner by way of discipline, he would be dealt with by the Police Service Commission by way of discipline. And absent all matters that are relevant to his mitigation being taken into account, it is possible that there would be very, very serious consequences for him. Dismissal out of the force, loss of pension, and in those circumstances, it would be extremely unfair to him, in our submission, that a proper mitigation take place in circumstances where there was a full and proper understanding of the way the Act operates and what kind of steps need to be taken by the Commissioner as well as Independent to ensure that officers properly understand what their duties are. So we would invite the court to remit any sentence to the Court of Appeal. So unless I can assist your
Thank you
lordships
very much
further.
indeed. Ms. Barrow? Nothing from me. Right, thank you very much. Now, Mr. Commissioner.
My lords, I'm wondering if we can have 5 minutes to reassemble on this side.
Yes. Do you need us to rise?
I would be pleased.
Well, slightly unusual, but why not?
My lords.
Yes.
I thank you for the short break.
Not at all.
My lords, a preliminary point that I should answer. My learned friend, in relating to the Indicom Act, spoke about the section about supervising and managing investigations,
Yes.
and made out that a large number of Indicom investigations are indeed conducted by the police, but managed by Indicom. That is in fact not so at all. Indicom hears about 600 to 700 new complaints every year. And those that are supervised by the police, done by the police and supervised by us, would be under 10 a year. Those that we send to the police for supervision would be those where there are no injuries, certainly no death, but where it only relates to some breach of police rules, such as non-action or rough behavior in terms of not treating the citizen in a courteous manner. But certainly once there's injury...
Most of the serious cases,
Yes,
you investigate yourself.
indeed, because it is our view that we would breach the procedural obligation if we were to send those to the police for investigation and we would supervise. I would first then deal with the Diah case, and then I have a few short points on the prosecution point.
Right.
The Diah conviction point, I mean. My learned friend makes out that the charges relate to refusal to hand over the weapons. One charge related to refusal to hand over the weapons. The other charge related to terminating the access of the investigator to the weapons. He already had them on a desk, already given to him by the police, the initial investigator of that station, the initial JCPC, and he had them there, and Mr. Diah took them up and ended his access to the weapons. The second information deals with the request made to Mr. Diah to return them, him having already taken them away. Now, a lot has been said in my learned friend's submissions about the directions. But Mr. Diah was not charged for breaching the directions, because the directions created no criminal offense. He was charged for breaching Section 33, and in particular, the particular powers that Indicom has under Section 21 and 4 of the Indicom Act. And if I may say so, the error that the Court of Appeal by majority fell into was parsing these parsing these protocols and force orders and not examining the statutory authority of Indicom to make the request and to have access to the weapons, and Mr. Diah's duty to comply with the request for access and to not terminate the access. Section 21 of the Indicom Act page 912 of the bundle. It's volume 1. Volume 1.
930, is it?
929 in my Bible.
929, I'm very sorry, 929. Section 21, the Commission, and I remind, the Commission, by Section 26, all members of staff can act, may at any time require any member of security forces, specified official, or any other person who is in subpoena able to give assistance to furnish a statement of such information and produce any document or thing in connection with the investigation. So it is that duty, and under subsection 4, having the power of a judge of the Supreme Court. or subsection 4 of 21. So once weapons were taken from him, it was that, it was a breach of that authority given to him in law. And I earlier pointed out section 4, 2A of the statute, that he should have access to all reports, documents, or information, and specifically the Parliament, including any weapons. Now, the trouble is, the respondent is now saying the directions provided him lawful justification or excuse. But that was not the defense at trial. His defense at trial that he didn't even know about the directions because they were not enforced orders. Our position was, at trial, well, you are obliged to follow these legal provisions in the statute. And my defense says the Commissioner of Police erred in not telling the members the law. Officers didn't know what to do because the Commissioner of Police has not told them the law. But each man is obliged to be judged objectively by the law as it stands. And indeed, in his unsworn statement, Mr. Diah revealed that he had some understanding of the law, because he said, I was aware that Indicom was obliged to have access to the weapons. But he didn't know for how long.
In any event, you say, even if he was ignorant of the law, that doesn't render of any less.
Indeed. But let me take you to his unsworn statement. I think it's important that I do. It is volume 1 of the electronic bundle. It's page 61. I'm sorry, it's page 68. I should use the numbers at the bottom. Yes. So he begins his unsworn statement, and I'm sorry. Yes, I find it. Okay, I want to take this to you shortly. Yes. He says, so there we are. He, in the first page at 68, he explains his role. Then he at page 70,
yes,
he arrives at the station and he encountered Mr. Philip Anderson processing policeman, and he says, he at paragraph 238, Mr. Phillips Addison said to him, the gun is supposed to be placed in a box. I pointed out to him at that time, this would have been a normal procedure, so what's the new change? I called my commanding officer, Mr. Heath, and then Mr. Anderson followed him, and asked that the recovered firearm be put in a box. Mr. Lauren Campbell approached him, and he said, I'm investigating a crime. What are you investigating? Then Mr. Misha Dawkins approached him, asked him to speak to Mr. Morgan, a director of complaints. He didn't accept to speak to Mr. Morgan. Paragraph 243, he then sets out his problems. Section 4 of the Independent Commission Investigation Act defines the functions of the commission. Subsection 2 says that the power to inspect and have access. What was access? How was access defined? By whom? It was not clear to me at the time. These are mistakes of law. How long should access be granted? Who determines that? And he says because he was the manager, he is the one who determines it, he took the decision to proceed. Subsection 3 speaks to a warrant issued by a justice. None was presented to me by Indicom. This is not a case that required a warrant. And then he says he thought about the Firearms Act. We have already demonstrated that it would not be a breach of the Firearms Act. Then he says his investigative experience was that they didn't need to box the guns anyway. A point had been made in evidence, my lord, that the guns were needed to be swabbed for DNA and such things. And he's saying that was unnecessary for Indicom to do. So in the actual defense of Mr. Diah. He does not maintain that the directions were a cause of his disobedience. But we have to ask ourselves this question. Could the directions alter the law? And the answer is certainly they could not. And the directions do not attempt to do so. The directions begin at their preamble. Yes, they begin at their preamble by saying it's without prejudice to the rights, privileges, and obligations of the Commission and the constitutional force on the law. And the directions are to, as my Lord asked, are to work in situations where it may be impossible for INDECOM to get to the scene, or it may be that the scene will be rained out, or some other form of, some other catastrophe may cause us to have to depend on the police to do some packaging and processing. So the directions speak as to what the police can do. But I take you to page 111. These are the requirements of a senior responding officer. And Romans 7, it says, confiscate and label firearms and ammunition in accordance with the directions set out at section 11 herein. And 11G says, 11G is on page 118. One member of the JCF has recovered an item from an incident scene before, during, or after the completion of INDECOM's examination of that scene. That member shall immediately advise INDECOM of the existence of the item. The said member shall take all necessary steps to surrender the item to INDECOM while preserving the chain of custody and integrity of the evidence. It is, when these provisions and directions are read as a whole, it is our submission that they do not support the submissions made by the respondent. Indeed, section 13, which was relied on by the respondent, the very last thing it says at 13E, 13.2E, is sealed and packaged in the manner prescribed by INDECOM. And the evidence in this case is that in fact, one investigator, I believe Mr. Stevenson, complained that Mr. Diah was handling weapons with his bare hands, and that there was no such sealing and packaging. Indeed, the other argument made is the mens rea argument, that there's a level of uncertainty created. And the level of uncertainty created, as described by Mr. Diah, was an uncertainty as to law. My learned friends are saying fact, but we have clearly shown it was as to how long access should be, who should have access, whether a warrant was required. These are all legal questions which he was grappling with, and he made his own legal decisions and was set wrong by his own decision making. And the other thing that they relied on again was that he followed Superintendent Pinnock's instructions, which is a superior orders point that we have made before. I will now turn to the prosecution point for my brief response on that issue. I would think, my lords, that when we look at this appeal, the real issue is what is meant by functions. What is meant by functions is a real issue. And I know it was grappled with at 28(1)B and grappled with throughout the Act. when we look at the definition section of the Act, it says functions includes powers and duties. Now, I would submit it is not circular. I will say why. It asks the Commission to consider what its obligations are, what its duties are. And the question is, are those duties restricted to what are in the four corners of the statute? That is the question. And the board, I would think a year ago, in the Jamaicans for Justice and PSC case, criticized the Police Service Commission in Jamaica for restricting its view as to its duties to the four corners of its statute, and failing to consider that its duties must begin with the obligations to protect and safeguard fundamental rights as required in the Constitution. And I would say, and I would submit respectfully, the same applies to Indicom. And in that area, Indicom has a special responsibility regarding these matters. But I will give an example, my lords, as to how this is applicable to 28.1b. The argument made about 28.1, about the whole 28, is that if there were a private prosecution, perhaps, we could not provide material to aid the private prosecution, or because it's not part of our functions. And the only prosecution, for example, that we could aid is one conducted by the DPP, is the argument made. Let us suppose the Commission, in its investigations, received a report or had material of a child in danger, a child in serious jeopardy. And the Commission had that information. Could the Commission say, we are not going to give this to the Children's Advocate, the commission in Jamaica that deals with children's matters, because there's nothing in the four corners of our statute that says sharing information with the Children's Advocate or any other ombudsman is permissible? I would say that we would be rightly criticized, because I would say, and I would submit, that part of discharge of our functions must begin with our constitutional obligation. And we would have to say there's a constitutional obligation that we would have to safeguard the welfare of this child, her safety, etc., which would dictate to us that we release this information to the proper authority.
What restriction does Section 28 impose upon the Commission in relation to the release of information?
What restriction it would say is we cannot do that if it is injurious to national security and international relations. That would be the question that we would have. That would be the only legitimate contention that we could argue to refuse to release information like that.
Notwithstanding the text of the provision, you say that it should be interpreted on the basis that the only restriction imposed on the Commission releasing information is that if the release would imperil national security.
I would not want to add only, because certainly the Commission would not be releasing information willy-nilly to a tabloid, just merely for, but there must be some public interest reason for good administration.
That's not what Section 28 says.
28 says, necessary to make in a discharge of their functions. And I'm saying functions must be read broadly and not confined in the four corners of the statute, just as the board said in JFJ and PSC.
I see.
That's what I'm saying. In that regard, I would pray in aid the decision in Scopelight, which is at volume 3, tab 50. This is amongst my final points. So,
Yes?
in the Scope Light case, this is about the police.
Have you got a page number?
Oh, I'm sorry. 1879,
Thank you.
tab 50. This is a case about the police having seized evidence on the pace, tab 52. Oh, yes, it is 52.
Scope light, tab 52.
52. Having recovered evidence on the pace, and the DPP have decided not to prosecute the matter. The matter was going to be prosecuted by a NGO called FACT, and the question was whether it was right for the police to retain the material and give it to FACT to aid their prosecution. If we go to the body of the judgment, I go to page 1894 in the electronic bundle, which is paragraph 36, ending,
Yes.
where Lord Justice Levison was considering whether the CPS decision not to charge meant that the CPS was the sole arbiter of the public interest. And he agreed that they were not the sole arbiter of the public interest. That's at the end of paragraph 36.
Yes.
Then they relate the power of private prosecutions. Paragraph 39. Thus, if it is in the public interest that other bodies should be able to investigate and prosecute, because of strain that the CPS would otherwise face, it's equally difficult to see why such a prosecutor should not be able to use material seized by the police, whether while investigating the offense to which material is relevant or some other offense.
But there's no equivalent statutory provision in stake here, is there?
I use it to argue by analogy.
Sorry?
I use it as an analogous
Analogy,
argument.
yes.
Indeed.
But the analogy has to comprehend the statutory background.
Indeed, but the comparison is that the police were required to seize and hold material for a public interest reason, and not and the decision of the CPS not to charge did not terminate or did not mean that there was no more public interest reason in the police keeping the material and handing it to the private prosecutor. So similarly, if the DPP were not to charge,
Yes.
Indicom or a private prosecutor charging could have use of the material recovered in an Indicom investigation, and it would be appropriate to do so because functions broadly considered would include the prosecution.
Yeah.
I believe I'm coming to my final point.
Thank you very much indeed, Mr. Commissioner.
Yes, this is my final point. My learned friend makes the point that in the United Kingdom, the arrangement is that the body which is akin to Indicom does not prosecute and sends matters to the Crown Prosecuting Service. I think it's important to point out that that was achieved by statutory amendment to the Prosecuting of Offenders Act here in the United Kingdom. Because if left alone, if there was no explicit provision like that, it could very well have meant that the body in England, I think it's called the IOPC, I believe, that body would be in the same position Indicom is now in. So to compare the UK situation to Jamaica's indeed makes our point. To achieve a situation in the United Kingdom where the prosecutions of IOPC matters are dealt with by the DPP exclusively had to be achieved by statutory provision. And I know I said final, but there is a, the question was raised as regards judicial review of the DPP's decisions.
Yes.
There are two matters before the court now for judicial review, which have occurred since this Court of Appeal decision.
I see.
Prior to this, we have had a successful judicial review of a clerk's decision in a preliminary inquiry, where the matter has now been put back for hearing. And we have submitted on the side a report we submitted to Parliament, our very first report to Parliament, our first annual report, where we pointed out the long delays that were attendant on waiting on DPP rulings. I think they would average the average would be years of wait on a DPP ruling. That is one of the conditions that would have been well aware to judges of the full court. Unless I can be of any other assistance.
Thank you very much indeed. You'll understand that we will have to give Ms. Kaufman the opportunity to make submissions on this if she chooses to do so within 7 days. Thank you very much indeed, Mr. Commissioner. Thank you. Now, Mr. Fitzgerald.
You could direct the police to investigate, but of course that's not the totality of the powers. Under section 4.1, there's a completely autonomous power to conduct your own investigation. So it's simply not true that the investigations under section 14 are the only investigations they can conduct. 4.1 expressly says it confers a power to investigate themselves independently and autonomously. And as my learned friend said, that's the norm. So the second point is that where it's said there's been no criticism of the DPP, one does have to recall that between 2013, when the full court gave their judgment, and 2018, when the Court of Appeal gave their judgment, the Indicom was operating the power to prosecute. So there's very little time in which one can see the DPP operating solely and to the exclusion of Indicom. My Lords, the further point, just to look at the Constitution very briefly, section 13.4 of the Constitution, tab 3, page 857, makes clear that the chapter, so at the bottom of page 857, makes clear that this chapter applies to all law and binds the legislature, the executive, and all public authorities. So, as a public authority, the Indicom is bound by the duty to give effect to the rights. The point was made, the rights in issue are not solely the right to life. It can also apply where there's sexual assault or beating up, but that would be covered by Article 3, where there's plenty of decisions that if the state fails to properly deal with or investigate serious violence falling short of death, that's covered by Article 3. And my learned friend said in relation to Gale, Volume 2, tab 37, that there were no failures identified of the prosecutors. Can I just indicate she invited you to read paragraph 99, and I also invite you to read it. It's quite clear that there was a criticism of the approach taken to joint liability by the DPP, and it's quite clear.
Do you mean joint function, or?
Sorry?
Do you say joint liability?
Sorry, joint enterprise. Yes.
Joint enterprise.
I mean, the DPP was saying, I can't identify exactly who kicked who, or who
beat who? Who beat Mr.
Who
Yes.
did what? Yeah. And what the IACHR responds is, well, if you know who's there, the doctrine of joint liability would apply.
That was hardly sort of institutional criticism.
No.
They just messed up the law in that case.
No, I accept that. But at 114 sub-paragraph 3, that's page 1416, what they say is, and so that's in the Gale decision, they talk about legislative changes to deal with the way that such incidents are both investigated and prosecuted. So it's not limited solely to investigation. And my learned friend said that, well, you can have two parallel systems. You can have a separate body to investigate and a separate body to prosecute. But equally, and where the problem is as insistent in this case, you can have concurrent jurisdiction or coordinate jurisdiction. And in our respectful submission is that firstly, that the public authority of Indicom has the common law power to prosecute. And we've referred the board to the Hunt decision, which my learned friend took you to at paragraphs 28 to 29. We don't respectfully accept that that's limited to the fact that they are officers, that it was a prerogative power. And Hunt is applied in Rollins. And so if one goes to Rollins at volume 3, tab 50, paragraph 11, so we're not any longer dealing with the Inland Revenue Commissioners with this argument about the prerogative, and one sees this...
You've got a page number.
Yes, sorry, it's 1861 in my lords. 1860 in the electronic, 1861 in... 1860 is what I'm...
Don't worry, I'll find it.
Look at paragraph 10. And one sees there that there's a reference to the Robinson case, and then at paragraph 10 there's the reference to Hunt, which is being applied, and it would be surprising if the Inland Revenue were not in a similar position. And then it states at paragraph 11 that the general position, therefore, is that the FSA has always been able to bring any prosecution subject to statutory restrictions and conditions, and provided it is permitted to do so. So they're directly applying the Hunt principle to the FSA, and not saying, oh, well, Hunt is some decision which depends on the special position of the prerogative. They're saying, therefore, the general position is that most statutes which create offences do not specify who may prosecute or on what conditions. And then it goes on, it follows that before the enactments, the FSA could have prosecuted. And then at paragraph 14 again, against the background of having cited Hunt, the general, this is at 1862, the general position before the enactment was that the FSA had the power of a private individual to prosecute, provided that this fell within the scope of its objects in prosecution. Sorry, and prosecution was not precluded. So the test that's developed there is it within the scope of its objects?
Isn't that the equivalent of functions, where the relevant body has a mem and arts, as I think, well, FISMA clearly did, and I suspect the FSA did as well. Yes. Whereas here we're looking for functions in the statute itself.
Yes. My Lord, can I just try to make it specified a little bit more clearly? So the question, as my learned friend indicated, is how widely you interpret the concept of functions. How wide are the functions? My learned friend's urging a restrictive interpretation solely confined to investigation. And we say one looks at the overall function, the language that's used in several of the decisions. But it may be within your function, and we would submit it is within your function, if by reason of the task that the statute requires you to perform, you are peculiarly advantaged to prosecute. And that's Hunt at paragraph 20, tab 32, paragraph 20, page 1299, and Securiplan, volume 3, tab 51, paragraph 11. So how do you test the question, is it within your function? One test that's applied, both in Hunt and Securiplan, is, well, does the task that the statute requires you to perform, in this case, to investigate serious misconduct by the police, make you peculiarly advantaged to prosecute? If so, the statute, by putting you in the position where you are peculiarly advantaged, is making it part of your functions. And, my Lord, going on from there, my learned friend was asked by my Lord Briggs, well, what about JR? How is it that it's their function, if their function is solely to investigate, that it's also their function to judicially review a decision of the DPP not to prosecute? I mean, i.e., if they've got nothing to do with prosecution, how can they say, well, our public money can be expended on judicial reviews?
Well, all you've got to satisfy for judicial review is that you have locus.
No, my Lord, that's what you've got to satisfy the court of.
Yes.
But if you're deciding whether it's one of your functions and the money that you've been given by Parliament, you can properly spend because it is one of your functions to judicially review, you've got to ask yourself, is it one of our functions? Not what the gatekeeper court will do, but whether you can properly say, this is one of my functions. Now, my learned friend accepts that it is one of their functions, i.e. it's within their statutory remit to judicially review. And the reason she gave was that when you give one of your reports under, under section 17.9, no, it's 9 where you give the recommendation. You can give under 17.9, you can make a recommendation. The Commission shall then prepare a report on the investigation, including its recommendations arising therefrom.
Yes, one can quite see how, even following your line of reasoning, that it is a function of INDECOM to make sure that reports made by it to the DPP are followed up on.
Yes.
But it's taking a further step to say that ergo it must be their function to prosecute.
Well, my Lord, can I just take it in steps then?
Yeah.
The first step is, therefore, they are entitled to concern themselves with whether there should be a prosecution or not. That's accepted. And they're entitled to judicial review if there isn't a prosecution. Therefore, it is one of their functions to concern themselves with the question of whether there's a prosecution or not. It is, in our respectful submission, that breaks down the thing. It's investigation here and prosecution there, and they've got nothing, that never the two shall meet. Why can't they, as a public authority with the constitutional obligation under 13.4, also say, and if we regard it as necessary because we're peculiarly advantaged to do so, it's part of our functions to prosecute ourselves.
Well, I think Ms. Kaufman suggests that the question of prosecution and investigation are in hermetically sealed compartments. But what she does say is, while it may be admissible for the INDECOM to judicially review a decision by the DPP not to prosecute, when it has gone to all the pains of investigating and producing evidence that could easily sustain a prosecution, it's a step too far to say that you then must follow through and say that it becomes a function of INDECOM to prosecute.
Take point that my learned friend makes. I simply say, one, we've broken down the hermetically sealed compartments. 2, if one says, well, you test the question of whether it's your function by asking whether you are peculiarly advantaged to perform the task of prosecution, Indicom is. And thirdly, I would submit that once Parliament has given them this special knowledge, special information about the nature of the crime, that is a reason for saying it is part of the function to use that to prosecute. My Lord, that's the way that we respectfully put it. But can I just run through very shortly, really all the other points that my learned friend made by going through the statutes up to section, the statutory provisions up to section 28 were really as consistent with a concurrent or coordinate jurisdiction on the part of the DPP, just so that 10.3c, the duty to notify, and my learned friend accepted that's just a duty to notify. The section 14, you can supervise an investigation, but for 1A, you can actually initiate it yourself. The reports under section 17, the fact that you can make a report with a recommendation under section 17.9 doesn't mean that all you can do is to recommend. And then section 23 really, in our respectful submission, doesn't help, because that clearly, as my own friend indicated and accepted, section 23 is really entirely to do with recommendations to the force. So that's protocols or procedures being reformed. It's not action to prosecute in an individual case. And so all of them in our submission are consistent with a coordinate jurisdiction, including section 25. If the DPP is prosecuting, that then you must assist, whether because they've taken over your prosecution or because they've prosecuted, or the DPP's prosecuted himself or herself. And then as to section 28, I think the court has the battle lines clearly drawn as to what we say about that and what my learned friend says, but we don't accept that section 28.2 should be interpreted as excluding any possibility of a prosecution. The words are shall be called upon, which really has to be referring to compulsory process. Shall be called upon to give evidence in respect of or produce any document. Suggests compulsion, whereas under 28.1b, provided the broad interpretation is given to functions that we invite the court to adopt, then the Commission has the power to make such disclosure as it thinks necessary, and if it does so, it's not inconsistent with any duty imposed by this section. My Lord. Oh, yes, I've just been handing out the question of arrest. As I understand it, in relation to, well, can I just make my submit? I don't understand it to be disputed that if there were obstruction under section 33, the power of arrest would not arise. That's to say, it would be, on my learned friend's construction, in furtherance of the powers under 4, 13 and 14, if someone obstructed you in the course of the investigation, the power to arrest would arise, and so would the powers and privileges of the constable in other respects.
So there would be a power of arrest in this?
Well, I think that must follow from what my learned friend submits, but I don't know whether she accepts that.
I see. There are so many negatives in the sentence that I wasn't quite sure where we came out.
If if you have the power under section 20, subsection 1, to arrest for the purpose of giving effect to sections 4, 13 and 4, well, if you have the power or powers of a constable for the purpose of giving effect to sections 4, 13 and 14, those powers obviously include the power to arrest. And even on my learned friend's interpretation, which is that giving effect to sections 4, 13 and 14 is limited to dealing with someone who is obstructing your investigation, it must follow from that you can arrest someone who is obstructing your not providing evidence or obstructing your getting of evidence, and that you would then have the same powers of the constable to cover you.
Under section 33.
Yes, yes. So section 20 gives you the powers of the constable,
Yeah.
and then if
But they are available for offences under section 33.
yes,
Yeah.
yes,
I'm not sure that's disputed.
No.
yes, and obviously.
Yeah. Do you dispute that, Ms. Kaufman? No. Agreement at the Concord.
My lord's on this happy note of Concord. Sorry, I looks like my lord, I'm just asked to make the further point that therefore, if you need to arrest for the purposes
Yes.
of an ID parade or something, it would follow in our respectful submission that on the concession about it would be for the purpose of giving effect to sections 4, 13 and 14. So we would add that submission.
Thank you very much.
Those are my respects.
Well, we're all very grateful to Council for the excellence of their presentation and the relative economy of the presentation. I hope that my encouragement to succinctness wasn't taken as anything more than gentle persuasion. But in any event, we're very grateful to those who made the oral advocacy, or who engaged in the oral advocacy, but also, of course, we're very conscious that there are those who stand or sit behind them who contributed massively to that, so we're very grateful to them as well. The board will take time to consider what advice they will humbly tender to Her Majesty. The court is now adjourned.